Okay, dear colleagues, may I have your attention, please? We have come to the last session for this day, a very exhausting one, I believe, but we are approaching the end and our dinner plans. So in this session, we have 3 presentations. 2 are online and 1 will be here in the conference room. The first presentation is by Professor Giovanni Tuzet from Bocconi University School of Law in Milan, Italy. So we are now going virtually to Milan, and we have a presentation of a rather interesting title. Is this Caravaggio Caravaggios? On property rights, contract, and deductive information. So, Professor Tuzet, please, the floor is yours.
Thank you very much. Thanks for having me virtually, because unfortunately cannot be there. I want to thank especially Professor Jasminka for having encouraged me to make this presentation here, even if not there physically. My topic is about a topic in contract law theory, and I'm going to present it briefly in the interest of time, since we're a bit late, and unfortunately I have to leave at 18:15. So I'll try to be brief, and hopefully we will have some time for discussion at the end of the presentations. So my title is about a problem concerning a contract where a thing that was sold was a controversial item, in the sense that at some point it wasn't considered to be a Caravaggio's artwork, and eventually it was considered so, and therefore there was an issue about the validity of the contract of sales. Let me tell you the story. This is a version of a painting by Caravaggio, which is called The Card Sharps. This is a version that was sold by Sotheby's some years ago, and it's not the most famous version of the artwork, because the famous one, which is considered to be the original version of the artwork, is in a Texas museum. What everyone recognizes as the original artwork is there, and the version at stake was sold by Sotheby's at an auction price of 42,000 sterling as a copy of the original painting. So the value was not insignificant. I mean, the work was sold by Sotheby's, the price was not, insignificant, as I just said, but it was considered to be a copy, right? Now, prior to the auction, to tell you more about the story, the former owner, Mr. Twades, asked an assessment of the painting by a Sotheby's expert, because he had heard of stories like this, paintings that were considered to be copies of the original artworks that eventually were assessed differently, and some experts concluded that no, they were original paintings. They were not copies. They were not copies by other authors. They were, in some cases, other versions of the same subject by the same painter. In this case, it would be Caravaggio. So the same artist makes different versions of the same subject. So he had the hope that the Sotheby's expert would have told him, look, we can consider it as a Caravaggio's. But the experts of the auction house said, no, this is a copy. We have no reason to consider it as an original artwork by Caravaggio. So he said, well, okay, however, let's try to sell it for an auction price, since it has a value, even as a copy, it has a value. So it was sold, and after the sale, the new owner, a renowned Caravaggio scholar, Sir Mahon, carried out extensive investigations into the painting. let me tell you another part of the story. He didn't buy the artwork himself, so he wasn't participating in the auction in person. There was another person participating to the auction in his interest. That's an interesting detail. However, he was the new owner, and he carried out extensive investigations into the painting. The painting was cleaned, it was restored, and examined by another expert. He had his own experts. He selected one of them, an Italian, by the way, expert. And as a result, this expert, hired by Mahon, Sir Mahon, said, well, we can consider it a Caravaggio's. It's, in my opinion, an autograph replica of the text of painting. So Caravaggio himself painted different versions of the same subject. The Texas version is probably better or the best, but this is, in any case, an autograph replica. So it was attributed a value of 10 million sterling, so much more than what of the price, or the auction price. You can see? Now, Mr. Traitis sued Sotheby's, and he tried to have compensation from the auction house for what happened. And this is the part of the story that I'm going to tell you now very briefly, because it's not the most interesting part of the story, in my opinion. So he tried to sue, he sued, in fact, Sotheby's, claiming that there was negligence in what they did, and there was a sort of breach of contract. He alleged that the experts failed to adequately research the painting, failed to notice certain Caravaggio features that should have indicated that it had, this is a phrase that they use in the acts, Caravaggio potential, which is a strange phrase in a way, but anyway. That is to say that it might actually be a Caravaggio rather than a copy, okay? And he alleged that if Sotheby's had performed their duties towards him properly, he could either have sold the painting for much more money, of course, or he would have decided not to sell the painting and would now own a work of art of much greater value. His claim was dismissed, by the way, in a very nice judicial decision. I mean, it's a long one, but it's very, very, clearly written, very careful. In the decision, the judge reconstructs all the story. He says, well, who Caravaggio was, what he did. There's a long analysis of, his painting. And in the end, they said, well, the Sotheby's experts did what they were supposed to do from a professional viewpoint. So they discharged their duties, and the claim was dismissed. There's another aspect of the story that can be considered, which is the thing that I'm going to make right now. One could argue that there was some mistake affecting the contract, because he had a mistaken belief. It was not his fault, because the Sotheby's experts said to him, look, this is a copy. But anyway, if it is true that it wasn't a copy, it's an original by Caravaggio, he was mistaken. Mr. Traitis, the former owner, was mistaken. And if he was mistaken, one could argue that the contract of sales was affected by a mistake. And in particular, it would be a unilateral mistake. So Mr. Traitis, the seller, the former owner, had a mistaken belief about the nature of the work, while the buyer, Sir Mahon, well, he had the right belief about that. He suspected that it was a Caravaggio's, and when he restored it, etc., he had a confirmation of his belief, or at least this hypothesis, okay? So if you now follow the legal doctrine that contracts vitiated by a factor like mistake on one essential feature of the thing, or in this case of the painting, if you believe that contracts vitiated in that sense should be invalidated, well, you could have an argument to say that that was a contract that should be considered voidable. because of the mistake, because of the essential mistake that affected the contract. And I was wrong, not because of my own fault. There would be, in terms of information theory and information asymmetry, and the buyer, Sir Mahon, would in fact let's say, taken advantage from this information asymmetry, right? So if you buy that argument, if you follow this logic, there could be a conclusion like this. He had a disclosure duty. He had to disclose that he had some belief, or at least some hypothesis about the Caravaggio potential, or the potential nature of that work as Caravaggio's, not just the copy. Okay? And if he didn't disclose the information, what in fact happened, would be an argument for invalidating the contract. And this is at least, I mean, what happens in some parts of contract theory and legal practice. I mean, if there is an essential mistake about one feature of the object of the contract, can be an argument for invalidating the contract. And that's a general theory, a general doctrine in contract theory. If contracts are vitiated by duress or incapacity of one of the parties, or mistake in this technical sense, they can be considered void or voidable, right? As a general matter. But there are exceptions. There are exceptions to that. And one exception that economic theory provides consists in making a distinction between what is called productive information and redistributive information. The latter thing, redistributive information, is a bit, it is a bit weird category. Let's focus now on productive information. What's productive information? It's the idea that one of the parties to a contract can be in the position of having information asymmetry in their favor, because they have more information about the thing, and that information is productive in the sense that it enhances the value of the thing, or it creates additional economic value. It produces some economic value that wouldn't be the case without that information, and wouldn't be the case without investment in that information, because collecting information is costly. When you want to collect information about something, especially if it's expert information, you need to invest money in that, okay? So in some cases, you can have an information asymmetry that is generated by investments in information. And the information that is collected in this way can be productive if it's information that enhances the value of something, okay, which is the object of the contract. Now, the economic argument, which is pretty, straightforward in the logic of it, is that when you have an information asymmetry of this kind, you shouldn't impose on the party having that additional information in their favor a disclosure duty. You shouldn't impose a duty to disclose that information to the other party who doesn't have that information. Why is that? The reason is very simple. If you impose a disclosure duty on the party having that information because of investments in information, now, if you do that, then you will have a result which is the following. The other party who didn't invest anything in information would profit from the information that the other party has collected, paying money for that. And so the other party would be just a free rider, someone who gets the information because the law imposes a disclosure duty on the subject, on the party who invested in information. And if you do that, the party that collected information wouldn't do the same thing in the future in other cases. And any economic agent wouldn't do that because it's crazy. I mean, you don't pay information for disclosing it to someone else who is going to profit from that, right? So in order to avoid free riding, that would be the result if you impose a disclosure duty on the party having the information, that information wouldn't be found in the first place, okay? And since some information is socially valuable because it's productive of economic value, we shouldn't impose disclosure duty on the parties having that information. That's the economic argument, which is, I think, which makes sense, I think, basically. Okay, I find the argument convincing. And if this is the case, you can have exceptions to the general doctrine that an essential mistake on the nature of the object that is sold leads to a void or voidable contract. No, the economic argument is there are cases in which you shouldn't have that result. So you shouldn't invalidate a contract which is based on an information asymmetry, given investments in information and given that the information is productive. What economic theory calls merely redistributive information is a tricky category. Let's say that is information which is not productive in the sense that it doesn't make the so-called, the metaphorical pie larger. It's information that merely cuts the pie differently, so with different slices. The pie remains the same, but it's cut differently. And that information is not very interesting from an economic point of view because it's just information that a private agent can use for their own, in their own interest, but it doesn't have a social value because it doesn't enlarge the pie. And more, even more, if it's costly to get, the pie is even a bit smaller when you have investment in redistributive information, okay? But when information is productive, it's desirable, it's socially valuable, and therefore we shouldn't invalidate contracts based on information asymmetry of this kind. So my example of this Caravaggio thing is just one out of many possible examples. For instance, suppose that you go into a second-hand musical instruments shop and you see a violin which is sold at the price of €100, for instance, and you are a violin expert and you realize that it's a Stradivarius, okay? Because of your expertise in violins, you see that it is Stradivarius. Let's assume that. Do you have a duty to disclose that to the seller and say, look, you're selling this thing for €100, but it's worth, I don't know, 50,000, okay? Well, are we going to do that? Is the law going to do that? Is it correct for the law to do that and impose a disclosure duty on people who have an information asymmetry in their favor because they invested in being an expert in something? If you follow this argument, you have a reason to say that in all cases of that kind, there's no economic reason to impose a disclosure duty on party profiting from asymmetry of information. It can be the Caravaggio case, it can be the Stradivarius or whatever, okay? Now, if you follow this argument, it's appropriate to enforce contract based on such information asymmetry. And I'm going to pause right now. There's an argument, an additional argument that leads to the same result, which is the argument of the acceptance of risk or assumption of risk in contracts like this one or the violin one or similar cases. There's an assumption of risk. And therefore, well, why invalidate a contract if you find out that things are different from the way in which one of the parties had an expectation? I mean, that's part of the business, okay? However, and this is my last point, the economic literature on this recognizes that very often, or almost always, you don't find purely productive information in some cases, or purely redistributive information in other cases. So these categories can be okay, conceptually, are not found like that in real life. So in real life, there's almost always a mixture of productive information and redistributive information. And some authors claim that when that is the case, so information is mixed, it should be treated as productive information to incentivize and protect investments in information, right? But if you go that way, and it's true that almost always information is mixed, so you come up with the conclusion that any unilateral mistake in contract becomes, in a way, legally irrelevant, because any information asymmetry, which consists in information asymmetry, is going to be treated as an asymmetry consisting in productive information asymmetry, which doesn't impose a disclosure duty. So in the end, if you follow this logic, almost any contract vitiated by a mistake is no longer so, because you have to protect investments in information, and mixed information is going to be treated as productive information. So according to this economic argument, the general view of contract theory that essential mistakes on things the contract is about lead to invalidation is no longer the case. And that is puzzling, and it's a bit of concern. This is the original version, the Texas version, which is better than the Sotheby's one. And I stop here, and we'll have time to discuss more. Thanks.
Thank you, Professor Tuzet, very much for such a enlightening presentation. And I can say that the presentation really lived up to the promise and to the expectations of the title. It was as interesting and challenging as the title. So since you are about to leave us at 18:15, if I understood correctly, maybe we should also make an exception, as in one of the previous sessions, and open the floor now for any questions or comments that other participants would have for you.
No, I mean, it's fine. I mean, you can go on with the other presentation. I don't want to monopolize the discussion on my thing. So.
Okay, we already did that once. So in case there are some questions relating to what we have just heard from you, maybe this is the time to profit from your presence. We have a question here in the audience, actually two questions. Mina, please, but use the microphone so that the professor can hear you.
I'm not sure if this is the right question to ask, but I'm going to ask it either way. So I wanted to ask you, is that mistake really irrelevant in the sense of, like in Serbian law of obligations, that what is the subject of the contract, that painting is considered essentialia negocii, which basically means that that's the only reason why you are entering the contract. So basically you wouldn't pay anything or you wouldn't do anything in exchange if that subject is not the picture of that specific artist. So that's my question. Is it really that irrelevant?
If you don't mind, maybe we should collect all the questions and then, because there are some others. Professor Hasanbegović, you were the next one.
Thank you. Thank you, Giovanni, first for the presentation. It's extremely interesting, and I had the opportunity to talk a little bit with you about, but still my question goes maybe in the same direction. First, this differentiation among information and dividing them in productive and redistributive, that is a theoretical, let's say, instrument in dealing with some legal problems. that is an economic theory invention, if I understood well, but still can be useful in resolving legal problems. Is it so, or that make another meta level of problems? Now we have to qualify information, if it is productive or if it is redistributive. And qualification is always something that belongs to decisions about values. It is not, let's say, fact-related thing. We have to qualify first an information in this or that direction. So we have to have a value attitude toward information, and then to use, according to that qualification, that type of information for solving our legal problem. And I think that this meta theoretize that we often do sometimes it is productive, sometimes not, but blur the problem. And I would say, I would see the problem in, let's say, a similar direction. Yes, I know it's not a criminal case, but for me, it is important that Mahon didn't buy himself appears as buyer, because he is a well-known expert on Caravaggio. And if he is interested in buying that, that will make the price higher by the fact that Mahon is interested to buy that supposed to be Caravaggio or maybe Caravaggio. And then how so that if I understood, I have no idea about how it the things goes by Sotheby and so, but it is clear that Sotheby knows that he is an expert on Caravaggio, and Sotheby knows that what he buys is something that is maybe Caravaggio, supposed to be Caravaggio, and let's say maybe I am let's say too suspicious, but there are some elements of I would put it that maybe not in a fine terminology, but something like fraud. It is not easy to prove, but it is not something that we expect from that institution like Sotheby. And, you know, okay, Mahon invited an Italian colleague who is also an expert in Caravaggio to say about, and maybe they are equal experts. Maybe even Mahon is in that circles, maybe even greater expert on Caravaggio than his Italian colleague who should do it. Of course, it is not just an impression of Italian colleagues. There were a lot of analysis and very, very deep analysis of chemical structure and Röntgen pictures and things like that. Yes, but especially because of all these things, it seems to me at the end of story, not that much professional from Sotheby's side, nor from Mahon himself. And okay, and I think that there is no analogy, full analogy with this violin, Stradivari violin story. You, in a way, you tells us maybe we can construct something similar, but it is not. That would be also. It is not any shop. It is Sotheby that arranged the whole thing. And if by Sotheby appears a violin, then it is a little bit different if it is Stradivarius violin or not. So anyhow, my first impression was, oh, when we learned at the first year this Roman law, and you do something, we club precario, and you sell something to somebody in these manners, that contract is not legally accepted. There is nothing on this, but precarious, there is something precarious in my eyes. Maybe it's not easy to prove, maybe it's not possible at all, but I don't know why I have this feeling that is unfair professionally. Thank you.
Thank you. I think we had another question, Professor Padian. Mm-hmm. But you will have to use the microphone.
Sorry. I hope I'm not going to commit sacrilege, because I've learned long ago from Calabrese's The Cost of Accident that Italians, in addition to having invented Roman law and law in general, have also invented, or at least discovered, economic analysis of law. However, personally, I think whenever a person, very often when people enter into a contract, you can qualify it as productive information, that they're doing that on the basis of productive information. Wouldn't it be more reasonable just to put, at least in commercial transactions, law and economic considerations aside, and say there is the maxim, the principle, caveat emptor, but allow, in cases such as Sotheby's expertise, to sue Sotheby for malpractice, if you can prove that they have been seriously negligent, because they are the top professionals in the world, and just disregarding law and economic considerations in commercial contracts. They may have place in civil law, but the parties are weak and sensitive. Thank you.
Professor Tuzet, I think that these are the questions for you. We are eager to hear your answers.
Yeah, thanks a lot. Thanks a lot. Many interesting issues in your questions. Very briefly, the first by Nina. Why did I say that a mistake becomes irrelevant at the end of the argument? I wasn't saying that, endorsing that conclusion. What I said is that if we start with the standard legal doctrine on mistake, the general view is that contracts vitiated by mistake on essential features of the thing should be invalidated. Okay. Next comes the economic theory with the claim on productive information that claims that there should be an exception to that. Given productive information and information asymmetry, the free riding problem, etc., we shouldn't invalidate some contracts. But then, if you also say that, in fact, in any contract, there's a mixture of productive and redistributive information, then you should treat those cases with mixed information as cases to be treated as cases of productive information, then you end up with the conclusion that mistake is basically irrelevant. And that is a matter of concern, because in the end, it's really against what the law usually poses about mistakes. So it's in a way a sort of open question. The question is, do we want to go down that way till that point or not? And if we want to stop earlier, where do we stop exactly? That was the question. So I share your concern, but the question remains, I think, an open one, because I find that there is something correct in the economic argument saying, well, wait a minute, we shouldn't always impose a disclosure duty on a party that is going to profit from an information asymmetry, because when the information asymmetry is not due by chance or just casual phenomenon, but it's the result of an investment in information, and that is an important thing. We should protect that. And in this way, I'm going to respond also to Jasminka's claim. Maybe, yeah, you're right. That distinction creates an additional problem. We want to solve a legal problem, but in the end, we generate a new problem because we have to distinguish the two kinds of information. Yes, analytically, that is true. You fix the problem if you follow what I've just said. There is the suggestion of some people in the law and economics field who say, look, given that information is almost always mixed, there's a mixture of productive and non-productive information, that is productive and redistributive information, we should treat all the mixed cases as cases of productive information. That solves your problem, Jasminka, in the sense that judges need not go into a detailed distinction of the kind of information that is at stake here and there, but it leads to the conclusion that almost any mistake is irrelevant, which is a matter of concern. Some people, like Jules Coleman, have claimed that when information is mixed, judges should adjudicate which information is dominant, if productive information is dominant or redistributive information is dominant. But that is conceptually, that is interesting, but it's a very hard thing for judges. I imagine the difficulties that judges might have if they were supposed to do that in actual cases. So I'm not sure that that is a thing that can be operationalized. On Sotheby's and the other things, well, now maybe I don't have time to discuss that in detail, but it's a part of the game. I mean, if you want to participate in an auction house and you are a very well-known expert like Sir Mahon, you don't do it yourself, because of course, if you show to be interested in a certain item, everyone recognizes that, oh, maybe there's something more in that thing. It's not just a copy. Maybe it's a genuine Caravaggio. So in order to avoid that, you send someone else to the auction. Is that a fraud? I don't think so. I mean, if fraud is I think another thing. There's a fraud when you intentionally deceive someone. I don't think we have that in this case, or in the violin case. Is that a fraud not to tell to the seller that the violin is a Stradivarius? Another case, to give you an example, there are cases in which a company makes some aerial surveys on land in order to assess whether the land has some geological properties that suggest that there may be oil or some natural gas or some interesting deposit behind the surface. And in some cases, they had the belief that there was something of that sort, and so they bought some land without disclosing that information to the selling parties. And again, there was a problem whether they should have disclosed that. And the economic argument is, well, again, you have a free riding problem. If you do an aerial survey with airplanes and whatever, you spend a lot of money to discover that probably there's oil there, and then you tell this to the party who is owning the land right now. I mean, you are going to waste your money to waste, in a sense. You're paying for something that will be the benefit of someone else, and that doesn't work economically. No economic agent is going to pay that money for that thing. So there's a problem. I think there's a genuine problem there. Sotheby in the legal action, in the suit that Mr. Thwaites brought against Sotheby's, he tried to show that they had been negligent, yes, but he didn't succeed. There are interesting details in the judicial opinion. We cannot go into that right now, but he tried to show that they had been negligent. And the judge said, no, they did what they were supposed to do according to the standards of the profession. They made several tests on the painting, and to the best of their knowledge, apparently they said, no, it's a copy. Then, if someone else comes up with the opinion that it's a genuine Caravaggio, what should we do? Should we blame Sotheby's for that? Again, it's a part of the game. Maybe also the new expert hired by Sir Mahon, is wrong. Maybe that person is wrong and Sotheby's was right. But if the market accepts the verdict of Mahon's expert, now the painting has a greater value. So you see, it's a complicated thing because there are different actors that influence the market price of the thing by what they do and what they say. To conclude on what Professor Pajan said, yeah, any commercial transaction should be like that, and other transactions shouldn't be like that, if I got your point. I'm not sure about the meaning you give to the phrase commercial transaction, because what I was arguing concerns any sale in which the ownership of a good is at stake. Can be a violin, it can be a piece of land, it can be a painting, it can be whatever. I don't see clearly how to draw the distinction between commercial transactions that are going to be treated in one way and other transactions or other sales that are going to be treated differently.
Okay.
Thank you, Professor Tuzet. Our next speaker is our young colleague, Petra Stanojević, an LLM student here at the University of Belgrade Faculty of Law. And again, a topic related to justice in contracts, this time regulating modern innominate contracts, how, why, and when. Petra, the floor is yours.
Thank you. First of all, I'd like to say good afternoon to everyone here. I'd like to thank the organizers for giving me the opportunity to present my research here. Just one, sorry about the presentation. Yeah, when I started my research, I noticed that there are a lot of innominate contracts that are being conducted on a daily basis, but aren't necessarily recognized by law, and also a lot of them are conducted via the internet or other electronic media or electronic means. And oftentimes the contracting parties aren't really aware of the fact that they are entering a contractual relationship. And that's why I wanted to touch on this subject. I will just briefly mention some of the main points of my work. But firstly, I'd like to just show the three main contract types that I have analyzed here. First of all, there is a contract that I recognize as a sponsorship agreement or a sponsorship contract. Secondarily, I have noticed a few contract types that are, in my opinion, very similar to the first of those, to the sponsorship agreement. And in my work, I have explored and I try to argue that these three contracts that I will now analyze are basically the same type of contract and should be regulated in a unified way. So these are the so these are the firstly, thank you. The sponsorship agreement firstly, secondly, the influencer agreement or contract, and thirdly, brand ambassador agreement or contract. But before I get into all of that, I want to highlight one of the most interesting conclusions that I have reached with my research. There is something called an image transfer, which plays a very huge role when conducting these contracts. And I will analyze this phenomena, basically this process later on in the presentation. But now I just want to highlight that this is basically means connecting to people, to brands in a way that the public starts to recognize one via the other, in a way that the positive image that one holds in the public is transferred onto the other. So the sponsorship agreement is a contract between a sponsored on one side and a sponsored individual on the other, in which the sponsor basically agrees to provide some sort of support. This can be, for example, like a material support in a way that they provide monetary payment, or it can be in a way that they provide a transfer of a certain item or certain goods, or they can oblige to perform a specific service, while on the other side, the sponsored party authorizes the use of their image, their personal rights for like promotional purposes. This could mean that they authorize, for example, using their face or their name or their brand in a way that promotes the contracting party's image. And now we will go through the main obligations of a sponsor, and I have recognized the three main obligations. First, being some monetary obligation or a payment. Secondly, transfer of material goods, and like I mentioned, the performance of specific services. I just want to highlight that this isn't necessarily all black and white, since these are innominate contracts. It isn't always like this, but this is what I have in most cases what are the main obligations of a sponsor. When we talk about the transfer of material goods, this is very interesting to me at least. Because this can be, for example, transfer when it comes to, for example, sports sponsorships. This could mean the transfer of some sports equipment or some other equipment that holds the brand of a sponsor. And this can be in a form of a gift or in a form of a lease, meaning that in the case of a gift, there isn't obligation of the sponsor party to return these goods, these items after a specific amount of time, while in the other case there is such an obligation. And also there can be this transfer can be with direct direct compensation from a sponsor party or without it. I say direct compensation because sponsor party has obligations which can be deemed as a compensation for this transfer, and also the performance of specific services which can be various services. And now I have posed in my paper, in my research, two very interesting questions. The first one being, is the sponsor party obliged to inform the public about the usage of these transfer codes? What does this mean? This means that when a sponsor, for example, transfers or gifts some equipment with their brand name or their logo, does this mean that the sponsored party also has not only the right but also duty to use these products, and also to inform the public about the usage of these products? And I will not get into this in a lot of details right now, but I will say that I have reached the conclusion that, or I believe that they do have the duty to inform the public about this usage, because there is one of the main goals of a sponsor when entering this contract is this image transfer, is this connection via the public with the sponsor party. So I believe that it is, according to contract, they do have the duty to use publicly use these transfer items. And the second question being, can a failure by the sponsor to fulfill their obligation to deliver items, for example, in the case of material deficiencies, leads to a breach of contract of the sponsored party? Meaning that can there be a contractual liability, for example, in a way that there is a poor performance in sports events, which can lead to damaging the image? Can this lead to contractual liability of the sponsor party? And also, I believe that this cannot lead to this liability because there is because of the breach of the contract by the sponsor. And now I will go through the contractual obligations of the sponsor parties. As I have recognized, I believe there is one main obligation, which is like a promotional obligation, but I see it as like an active promotion and a passive promotion. Active promotion being the obligation to actively engage in the marketing activities which promotes sponsor's name or brand or reputation. For example, highlighting their business name, their brands, participating in the marketing activities, or exclusively using the sponsor's products. But on the other side, there is also something that I call passive promotion, which is basically enabling sponsor to market themselves via the connection with the sponsored person, enabling sponsor to use the personal rights of a sponsored person, their face, their name, or other personal rights in promotional purposes. And I also want to highlight that the sponsor's party obligation is a means obligation, meaning that they do not guarantee that this image transfer will actually be achieved. They do not guarantee that, for example, there will be more goods or services being bought, or that the reputation will be hired by the sponsor. But they only guarantee that they will perform their contractual obligations. And also, there is also one interesting question that I have posed here. Can a contractual liability of sponsored party arise in cases where they undermine their own image via the actions in their private life? What does this mean? There is also an obligation to act in a specific way. And acting, for example, having some sort of a scandal or other action in the private life of the sponsored party can lead to damaging their image, and by that damaging the image of the sponsor themselves. So there is a question: can they be contractually liable for damaging their own image? And I believe the answer is no. I believe that there shouldn't be that we shouldn't deem them as liable for actions in their private life. And now I will just give the I will just go through the image transfer that I have talked before. So in Serbian legal system, the causa of bilateral contracts is considered basically to be the fulfillment of the obligation of the other side of the contracting parties. And by this, this image transfer cannot be deemed as a cause of this contract. But before we go into that, I like to just give this definition that the image being the perception that is held by someone in the public. The image, for example, the way that the public interacts with them, the way that the public views them, and so on. An image transfer is a process in which the public, the goal is for the public to start associating one person with another or one brand with another brand in a way that the positive image of one of the parties is transferred to the other party. And there is a question: what is the role of image transfer in these contracts? Because this isn't the role isn't necessarily just one of the goals while conducting the contract. Because I believe the role is a bit more important. Because when sponsor or the other party enters the contract, their primary goal isn't necessarily for the other party to fulfill their obligations, but even just the mere fact that the contract is conducted can lead to image transfer, can lead to the public recognizing one through the other. And so I believe that this process holds a greater role when conducting the contract. And the two agreements that I have connected with sponsorship agreement is firstly the influencer agreement, which is basically a contract where one party or the influencer agrees to promote the product, services, or brand of the other party. And this is basically done mostly by social media, creating content, and so on, as well as granting the usage of their personal rights and promotional purposes, while the other party commits to compensating them or providing a specific type of support. And thirdly, the brand ambassador agreement the definition is pretty much the same. This is the contract when one party, the brand ambassador, commits to promoting the business name, products, and so on through communication acts, which most likely involve creating and sharing content, participating in marketing activities, using their products, and so on, and also granting the usage of their personal rights, while the other party commits to provide compensation or to provide specific services. So now I come to basically the thesis of my work, that I believe that these three contracts are basically the variation of the same contracts. And I believe that there are two main similarities between these contracts. Firstly, there is a reason for conducting the contract. This is some marketing purpose in mind. It is either image transfer or some promotional goal that they have in mind. And secondly, the nature or identity of their obligations, which I have gone through, but these are some sort of support, compensation, or transfer, and promotional services on the other side. So I believe that these contracts should be regulated in a unified way, and this should solve the problems of which law should be applied when we think about these contracts. And lastly, I just want to briefly go through how do these contracts interact with the existing law. And I have chosen law of advertising, and I have shown some definitions here, but I won't go through them because of the time. I will just try to answer three questions that I have recognized as important. Firstly, are these contracting parties, influencers, brand ambassadors, and sponsored parties, can they be deemed as advertisers or transmitters of the advertisement message? And this is basically something that is not is very hard question to answer. But I believe that they should that it is more likely for them to be seen as transmitters of the advertisement message because of the definition that is given in the law on advertising. But more important, can the content that they create be deemed as an advertisement message? And this is hard because on one hand, the law states that an advertisement message is any representation related to business or professional activities aimed at stimulating the sales of goods and services and so on. So via this definition, it seems that this content can be seen as an advertisement message. But the law on the other side states that personal posts that aren't related to the professional activities of the individual sharing them do not qualify as advertisement message. And the main problem here is that the content that we are talking about does have a marketing purpose, but is also personal. It is personal in a way that attracts customers, but it is marketing not the specific goods and services of the person sharing them, but of their contractual partners. So this is the problem that we are facing. And thirdly, does the prohibition of product placement in electronic media apply here on this content? This is also unclear what the intention of the lawmaker was, because on one hand, the advertisement message is defined in a way that it is not important if the message is communicated through electronic media, but on the other side, there is a prohibition of product placement in electronic media, so it is not very clear what the intention was. So at the end, I believe that this contract should be regulated in a unified way, because in a case of dispute, it is not very clear which rules should be applied or how the courts will look at these contracts. And also because of the question that I have posed earlier, I believe that this would be better for the contracting parties to be more sure of what they are entering when they are conducting the contract. So with this, I thank you for your attention.
Thank you, Petra. To be sincere, I was not aware until now how many different and complex legal issues arise with relation to these new occupations that we have, being an influencer or a brand ambassador, but you managed to convey all the relevant information in a concise manner. Thank you very much. The last presentation for today, we are now going to Brazil. We have Matheus Garcia Drawin from Pontifical Catholic University of Minas Gerais. The title of Matheus's presentation is The Importance of Rawls Social Contract for the Foundation of Law in this Procedure. Matheus, I will share the point now as we agreed, and please feel free to remind me to go to the next slide whenever you need it.
Sure, thank you. First of all, I would like to, are you hearing me?
Yes, working perfectly. And I will now share your PowerPoint.
Okay. Well, first of all, I would like to thank the University of Belgrade and all of you that are listening to me. It's a great opportunity, and I apologize that I'm not there in person with you. The title of my presentation, The Importance of Rawls Social Contract for the Foundation of Law and its Procedure. I specialize in philosophy of law, and I always try to build bridges between these two fields. I not always succeed, but what I mean is, when I say that Rawls has an important theory for the foundation of law and its procedure, what I mean is that there is underlying principles that guide political parties, that guide political governments to do what they do and to create rules of law. I would like to bring a first example of an interview made by Margaret Thatcher from the United Kingdom. She was explaining to the interviewer how the defense of the capitalist system is the same thing as defending free people, because you are only free inside the system of capitalism. I'm not saying that is true or false, but her actions as a political leader were based in that underlying principle. So this is why every time we look at a complex theoretical system, such as we see in Rawls' theory of justice, we should visualize two things. First, what he aims to defend, and second, where is he coming from? Where are his high grounds? Where is he coming from? And in his theory of justice, which is called Justice as Fairness, we can clarify both of those right in the beginning of his main book, A Theory of Justice, and he states, thank you, where he states, justice is the first virtue of social institutions, as truth is of systems of thought. A theory, however elegant and economical, must be rejected or revised if it is untrue. Likewise, laws and institutions, no matter how efficient and well arranged, must be reformed or abolished if they are unjust. And with that goal in mind, Rawls can be seen as an author who is philosophically between Kantian morality and utilitarianism. And politically, you can stop a little bit there, please. And politically, he is between liberalism and communitarianism, because his idea is not to give up on the individual rights of being free, neither the importance of equality in our society. So probably the most relevant aspect of his theory is a form of neo-social contract with the possibility of being summoned at any time by any free and rational person. And because of that, there is an abstract force that usually is not put into evidence, as it should, in my opinion. And that in this fact that we can evoke through a thought experiment, the original position under the veil of ignorance at any time is fascinating, because we can do that in different periods of time across any culture to probably arrive in conclusions that even if these conclusions are not identical, they have a high chance of being reasonable. Just to use an example, in our discussion in the last panel, I heard the discussion between human rights and liberal democracies. And if you think about it deeply, human rights are defending more equality, more recognition for persons, and liberal democracies are defending more individual rights. And even if you disagree with that at some level, we are pursuing something deeper than mere facts. The facts are guided by this method of thought. So in order to clarify how abstract suppositions can in fact help us construct legal systems in which people can follow laws sustained by rational principles, my suspicion is that even Rawls did not give the necessary credit to his own, and by extent all others, forms of abstract argumentation, because he was trying to face a lot of criticisms from his time. And in facing them, I suspect he lost a bit of opacity much needed behind his own conception of the veil of ignorance to clarify his own theory. And without blaming him, he's focused too much in the contradictions within the United States community, way of seeing the world. And I say this following his own warning. Please, you can pass the slide. His own warning in a book called Political Liberalism that was published 5 years after A Theory of Justice, in which he states, citizens need to adjust and reconcile these two aspects of their moral identity in their personal affairs or on internal life of associations of which they are members. It may happen that they see their ultimate commitments and ends in a very different way from that which results from the political conception. It is possible that they have, and often have, affections, devotions, and loyalties, from which they believe they cannot or should not distance themselves, from which, in fact, they cannot distance themselves in order to evaluate them objectively. It is possible that they will find it simply unthinkable to conceive themselves apart from certain religious, philosophical, and moral convictions, or from certain lasting bounds and commitments. Basically, we cannot completely escape and be completely unbiased from our human nature. And with that in mind, please, you can press the slide, please. With that in mind, let's say in my mission of being a philosopher, I raise some questions that I would like to put to the community. And within the context of his theory, justice as fairness, we could argue that multicultural societies should have laws to protect minorities, for example, following principles such as Charles Taylor's equal value of cultures, combined with Rawls' principles of justice, specifically the principle of difference. But however, the inner motivation is to preserve a specific culture. May appear some contradictions. For example, the immigration problem in Europe. This is a situation in which more than one culture should be preserved at the same time. But if certain groups are outside, let's say, agreed principles of justice, it means they are, does it mean that they are less just, or even if they still possess a cultural equal value? Can they be considered a lessened form of organization, considering the value of a justice point of view? Or do they have a different kind of social justice, completely unable to talk together with another kind of value organization? That situation is an example that can demonstrate that certain principles can be applicable to opposite situations. The same principle can be applicable to opposite situations. But however, if they are purely political, without any rational morality behind them, they could serve antagonistic masters at risk of becoming irrelevant. So I ask, is that possible? Is that a possible call for the importance of metaphysics of justice? Do we need a metaphysics of justice, or at least a meta-ethics? Because that's the very thing that Rawls tried to refuse in his theory and tried to escape. In his other book called Justice as Fairness, a Restatement, he answered and clarified a lot of critics about his theory. And Rawls teaches us about two facts. The one in which I believe there's a lot of controversy, it's called the fact of pluralism. And the other is the fact of oppression. The first one, the pluralism, is evident by problems raised in my questions. For example, in a multicultural environment like Europe, with the immigration problem and applicable specific rules between countries can be an issue, even though they are behind defending the same principle. But I find the effects of oppression one that causes most complex troubles in what Rawls poses. And that quote from Justice as Fairness I would like to share with you. If we say a political society is a community when it is united in affirming one and the same comprehensive doctrine, then the oppressive use of state power with these attendant evils is necessary to maintain political community. Let us call these the effects of oppression. In the society of the Middle Ages, more or less united affirming the Catholic faith, the Inquisition was not an accident. Its suppression of heresy was needed to preserve the shared religious beliefs. The same holds, we suppose, for any comprehensive philosophical and moral doctrine, even secular ones. A society united on a form of utilitarianism or on the moral views of Kant or Mill would likewise require the oppressive sanctions of state power to remain so. Please, you can pass the slide. So in my point of view, of course, that Rawls' argument, it's not so simple. I don't have time to extend on that. And he has reasons to claim that justice as fairness should be more unbiased, for example. But even so, there is a chance of him going too far by putting both, for example, religious traditions and moral theories all in the same category, the one he called comprehensive moral doctrines, and sentencing them all to the need of state power in order to work, while his justice as fairness would stand apart. And because of that, I have yet another questions. Why to evoke abstract in the political thought? If we're talking about political problems, the law must be transcendently rational, not purely with Kantian perspective, but with the notion of Rawls beyond Rawls in the present question, considering that cultural differences are related to emotions. So any rule of law that aims to be international should have a transcendental reference which frees any method of arriving to reasonable principles of justice taking into account acting human emotions, even after the agreement on principles of justice arrive in concrete terms. For example, we can quote the Constitution of United States, that one of main virtues of them is the pursuit of happiness. So everyone defends and agrees that it is very important, the pursuit of happiness, but they never ask to define what is happiness. They presuppose that it's an individual choice, but that individual choice, that choice to make a definition of happiness that it's depend only in the individual person, have liberal and historical influences. So the idea behind the pursuit of happiness is unquestionable, but how we should apply that, it's kind of a mysterious essence that should be preserved by law and respected by that. And in this sense, Rawls' theory has to surpass itself by admitting that justice is more principle than rule at many times, and therefore his new social contract should have a universal abstract value without contradictions with later empirical results. The gradual revelation of the veil of ignorance, as he states in his theory, has a lexical order more relevant than the lexical order of his own principles. His principles are a suggestion of his own method, as a result of his own method. And this leaves us with the question about what are the abstract political ideas that compose the original position. What if we take this position itself to be a metaphysical idea? We must see, that's the final slide, so just a minute. Final reflections, please. We must see that Rawls' thinking is revolutionary in political theory, and the relevance of its proposal is undeniable, but we should follow his own advice of always trying to be rational and reasonable to form a sense of justice. It's another conception of his. So the conception of original position is always available, since it is a matter of a thought experiment. Therefore, always accessible for root corrections within our rational capacities for reflective equilibrium. When supposing a basic structure of society, Rawls evidentiates that basic human necessities universally exist, even if you disagree with what he calls primary goods. Does it mean there are some inner intelligence integrated universally in human experience, for example, suffering? There can be, and inspired by Rawls, some kind of universal Kantian multicultural justice, maybe. By using John Rawls' political thought as a basis for these questions, the goal of my idea is to renew some problems with the tradition initiated by the philosopher Immanuel Kant, by bringing more abstract form of hermeneutics as a special proposer of jurisprudence of principles that can be used both as foundation of national laws and rules and as an ethical centralized method of flexibility to international relations that can later reflect issues such as immigration, hunger, poverty, which are trying to solve the problem of human suffering, for example, and any other that may be hidden behind as real motives of certain forms of government. If we aim to create legal systems that are more immune to economical tyrannies and that are not just victims of special circumstances of its own time, moral doctrines should always have a place in the debate. Otherwise, the codes, rules, and decisions of our legislative and judiciary powers would just be created by lower forms of morality, and we would be at mercy of the worst of human imperfections, our selfish and endless personal desires. So we must remember, as Immanuel Kant suggested, that we must do the right thing just because it's right. And so if our political systems work within this moral dignity, I believe that all the difference would be made. Thank you very much for the opportunity. That's my presentation.
Thank you. With this presentation, we have heard all the presentations planned for today, and we should have some time left, but not that much time, unfortunately, for questions and comments relating to these two last presentations. So I'm opening the floor now for the discussion. Mina, please.
Thank you, Professor. So this is a partly a question, partly a comment to what Petra was saying, and it was really, really interesting. I wanted to ask you on the relations on the sponsor and sponsored person. So if per se we say that the person who is being sponsored is a big deal, not only influencer, I think that they can also be like football players or actresses, it doesn't matter, and they do something which can cause harm to the ones who are sponsoring them. For example, I don't know, you're probably familiar with the thing that happened to Casio a year or two ago. So can the person who did what they did, and then after that Casio took a big strike on their watches predominantly because of everything that happened after, can they do something with that football player in the sense of, and what is happening in practice? Can they, like, they're not going to have contract with him anymore, but can they have clauses to prevent that? For example, for him to give a monetary compensation to them or something like that before the thing that happened happens.
Are there other questions, comments? No? Then Petra, please, you can answer.
Thank you for your question. This is a very controversial thing in practice and also in theory. There isn't like a one unified answer. My opinion is that there cannot be a contractual liability. Can these clauses be in the contract? Possibly, but it is now. I am not sure if those could be if those clauses can be in according to the law, and also can they be how they would impact the contract. So I'm not sure. There isn't very much. There aren't that many practice on this, and the court decisions, especially not in our country. So I'm not sure how I would answer. I could only tell you my opinion on that, and I believe that there cannot be some sort of a liability. Obviously, the contract would not be in anymore with that person, but I don't think that there can be any liability per se. But thank you.
Thank you. If there are no more questions, then I think we can call it for the day. It has been a long day, and Tanasi, how shall we proceed? Shall we go together?
Yes. The panelists and the participants, they're invited for a dinner, and I suggest we immediately go for dinner, which is not far away from the faculty, so you just follow us, and in 2 minutes you'll be there. Thank you, and see you tomorrow at 8:30.
Yeah.
8:39, so 8:30.